We'll get started with the program now, the webinar. Mr. Zach.
Good morning, everybody. I'm going to walk us through the PEBB program appeals process. This first slide is important enrollment reminders. These enrollment windows are very important. A lot of appeals come from people missing these deadlines. Missing deadlines can have harsh consequences for employees and their families. For example, missing an initial enrollment window results in someone being defaulted into benefits, and missing other enrollment windows oftentimes means a dependent cannot be added to benefits until the next plan year. It's important, the initial enrollment window is important to remember. The deadline is 31 days from when an employee becomes eligible for the employer contribution, which is usually when the employee starts work, not when they receive their eligibility notice. And the annual open enrollment is usually 1 month during the fall. During this enrollment window, the subscriber will be allowed to make changes to their benefits for the following year, which will start on January 1st of the following year. We just got done with November's, and those changes went into effect as of January 1st, 2021. Next and finally here is the special open enrollment events. These are typically 60 days following a life event like a marriage, divorce, or birth. And these during this time they allow for changes to be made on an account during the mid-year. And if you have questions specifically about what changes can be made, please reference PEBB policy 45-2A, which is the special open enrollment matrix, and you can search that online on Google. Next slide. Appealing a PEBB program decision. When a subscriber is denied by the PEBB the program will send a letter that contains the appeal rights. Subscribers who receive program decisions have the ability to appeal directly to the PEBB appeals unit and do not need to use the appeal form for having the decision reviewed by the employer first. If you receive questions about program decisions from your employees, please encourage your employees to follow the instructions on the letter regarding how to appeal. Please also remind them to include any relevant documents and to pay close attention to the deadlines on the letter. Again, the PEBB organization does not need to make a decision or review these types of appeals. Next slide. Appealing an employer decision. On the other hand, when there has not been a program decision letter issued, it is the employer's responsibility to review the employee's request and make the initial decision before the appeal is sent by the employee to the PEBB appeals unit. The appeal form found on the PEBB appeals website is used when a PEBB organization issues a decision. WAC 182-16, 2010, and 2020 gives the employee the right to appeal eligibility and enrollment decisions or denials made by their PEBB organization. Next slide. Some general guidance for PEBB employers. WAC 182-113 or 182-12-113 explains various responsibilities that all PEBB organizations must carry out, which includes but is not limited to all actions, policies, and guidance issued by the PEBB program, which are necessary for the operation of the appeals process. PEBB outreach and training, our staff are available to offer guidance but not decision making. We encourage all PEBB organization staff who are involved in the PEBB appeals process to review all the applicable WACs, RCWs, and program policies linked on this slide. WAC 182-08 is the procedures, 182-12 is rules for eligible and non-eligible employees, and 182-16 is the appeals practice and procedures. Next slide. Now we are going to talk about the appeal process, starting with the employer decision and how to use the appeal form. When an employee has a request regarding their, we're still on that slide. When an employee has a request regarding their eligibility or enrollment in PEBB benefits, that request is sent to the PEBB organization for review. If the employer is unable to make the requested change, the employer should direct the employee to the appeal form. All right, we're ready for the next slide. The cover page on the appeal form explains 3 different situations. The number 1 describes if the employee disagrees with the decision made by their employee or agrees that further review is needed because the employer believes there was an error and directs the employee to fill out sections 1 through 3 of the appeal form and submit it to you, the benefit administrator, for another review. It also explains the next step in the appeals process, which we will go into in more depth on the upcoming slides. Number 2 describes the situation we spoke about a few slides ago in which the PEBB program makes a decision. While this form can be used to file an appeal in this situation, it is not required as the employer does not need to review a program decision. An employee can submit a written document / letter directly to the appeals unit in response to a program decision letter. And 3 on this, and the third situation, not pictured here, describes when an employee wants to appeal a decision by a PEBB health plan or insurance carrier. We will discuss this later in the presentation. Please note that we have not completed all of the updates for the 2021 appeal form. It is important for employees to use an updated appeal form that is found on the website. Occasionally, we will update the appeal form mid-year. This is another good reason to always obtain the form from the website as opposed to saving a copy on your computer. We are going to make updates to the PEBB program decision portions to bring some clarity to the situation between the PEBB program and PEBB organization decisions. We are now going to walk through how the appeal form works. Assuming the appeal relates to number 1 on the cover sheet and an employer decision is needed, the employee will need to complete sections 1 through 3 of the appeal form and send it to their employer for another review. It is important that the employee is the one that is filling these sections out and not the employer. Section 1 of the form is information about the person filing the appeal and information on who the appeal is regarding. It is helpful to the appeals process if we know who is appealing, whether it's a subscriber, an applicant, or a dependent. An employee or a former employee, a dependent of an employee is somebody who's a spouse or a child of the employee. And the applicant is somebody who is not currently enrolled in benefits, or that they're waiting to be determined whether or not they're eligible. Please note that the term appellant that we will use in this webinar is describing the person who filed the appeal. Next slide. Also in section 1 is space to fill in information on dependents involved in the appeal request. This section is important to fill out, especially if the appeal has to do with specific dependents or the family as a whole. For example, if a child was not added, this page is a great place to put down that child's information. It is not needed to list dependents who are not relevant to that appeal. Providing this information is useful in processing the appeal. And you can go forward one more slide as well. Make sure the employee fills out both sections 2 and 3 before they send you the form for the employer review. Section 2 needs to be filled out to indicate what exactly the employee is appealing. Some examples of reasons to appeal are wanting to change medical plans, dental plans, adding or removing dependents, or wanting to waive enrollment. If this section is not completed, it will cause delay in an order being issued. We need to know what the appellant is asking for before we can process their appeal. Appellants should be encouraged to go into as much detail as possible and submit any supporting documentation they have with their appeal. We often see appellants attach letters to this form if they cannot fit their request in the box. Next slide. Once the employee has filled out sections 1 through 3, they will need to send the form to you, the benefits administrator, to review the request again, and you will need to complete sections 4 through 6 of this form. Next slide. At the start of section 4 is directions for what the employer needs to do in sections 5 and 6. Section 5 pertains to the error correction process, which will be explained later in the presentation, and section 6 is the employer's signature. Next slide. Section 5 is for the employer to complete, and this section spans over 2 pages. Oh, sorry, looks like we're out. Go back 1 slide, excuse me. Section 5 is for the employer to complete, and this section spans over 2 pages. This part of section 5 allows the benefits administrator reviewing this appeal to provide their contact information. This information is important as we will oftentimes try to reach out to the employer for additional information. The date circled, which will be on the next slide, is an important procedural date and needs to be completed by the employer, and that is the date that the employer receives the appellant's request for review. Next slide. Section 4 continues on the next page. You need to provide the date of when the employer decision was made, as this date is used when the PEBB appeals unit determines if the employee's appeal was received timely. Additionally, the last part of Section 4 is where you mark your decision. Make sure you are providing both the date of when it was reviewed and actually marking your decision. If you decide that an incorrect decision has been made, where you need to complete Section 5, mark it here and then continue to Section 5. What happens if a BA does not mark an employer decision on the appeal form? If no employer decision is marked, this will cause delay in processing your employee's appeal, as we will have to contact you for a decision before we can process the appeal. When an employee does not send this form to their employer first, then we will send them a letter telling them their appeal is premature and needs to be reviewed by the employer first. Next slide. Section 5 allows space for the PEBB employer to explain the error and what the PEBB employer suggests to correct the decision or action. And now Tracy will talk you through the steps regarding the error correction process.
Good morning. So now if you're an employer and you receive the employee request for review form, it's important to note that if you identify the error that was made falls into the category of error correction, which is explained in WAC 18208, 187, and also in PEBB policy 11-3. If it falls into one of the errors in these categories, then the process stops there. The appeal form doesn't go on to, at this point, to Office of Legal Affairs. It actually gets corrected in a different manner. So the different 6 categories that make this error fall into error correction are failure to provide notice of eligibility to the employee, failure to accurately enroll the account, which can contain many different errors from attestation to forgetting a dependent, forgetting to enroll one of the dependents in dental, etc. And then failure to default enroll. And in default enrolling, typically happens when notice goes to the employee and the employee fails to return the form within 31 days, resulting in the need to default enroll the employee, but the employer forgets to, since they never received the PEBB form back from the employee. Next slide. Let me see here. Failure to accurately reflect the tobacco or spousal attestations has specific language in the WAC. It's also considered failure to accurately enroll. And the WAC also discusses enrolling an ineligible dependent or employee or dependent. And that's, specifically happens when an employer may have miskeyed the actual effective date for the employee and enrolls them early, or they misinterpret the eligibility of the employee and enroll them in benefits. And then the last one is when an employer fails to provide correct information to the employee that they rely upon. And they're, specifically, the biggest one that we see currently is if it's the first child. There had been a rule change a year ago that you have to submit those forms within 60 days, where previously, if you had a newborn child, there wasn't really a time frame associated with it. And so that's a current one, or perhaps forgetting to letting the employee know what forms are actually needed in order to complete the enrollment. Next slide. So when an employee turns this form into you and you see that it falls in this category, the majority of the error corrections occur when the event is more than 90 days. It falls without the lower limit. So when the employer agrees with the qualifying error and it's within the lower limit, it's just corrected. You're within your rights, it's within the accounting time frame, and the error just needs to be corrected. Now, whether that means you are able to just key it yourself or you have to send it in through Fuse to have ask for assistance with outreach and training, either way, if it's within the lower limit, you're just correcting the error. However, if it's beyond the lower limit and it's one of the 6 qualifying errors, you need to send it in through secure Fuse to outreach and training so that we can determine whether or not it falls under error correction and start that process. Next slide. One thing that's really important to note is that there are procedures and policy that are associated with correcting it, and the employer must correct the account. And that means that whether it's enrollment or terminating, spousal attestation, it's not, it must be done. And so as described in subsection 3 of WAC 18208-187, that also includes providing notice and recourse to the employee. So there are specific parameters and language that are used, which can be further reviewed in PEBB policy 11-3. Let's see here. Actions to take if the PEBB employer determines a qualifying error. It's important to note that the error meets the standard for error correction under the WAC, and that you have to contact outreach and training in order to start the error correction process. Once it's determined that the error meets the process, we'll go ahead and draft a notice to the employee and start the process of correction. If it doesn't meet the error standard of error correction, either we'll be able to just correct the account, or we'll, and then that may end up, since we're not able to correct it, it will need to go on to be completed and given back to the employee to be sent on as an appeal. So in the scenarios of when an error occurs, an employee completed the enrollment form with dependent verification, and the employer failed to actually key it or send it in through outreach and training for application to the account. And so when the employer finds that this hasn't been done and it's outside the lower limit, then they're going to reach out to outreach and training. And generally what that means is that if it can be corrected because it's within 90 days, then our staff will go ahead and help with completion of that correction. If it's outside the lower limit, then we'll have to go through the process. And in reference to this scenario of the request for employee review, that's where the form stops, and we'll then continue on with the error correction process. It's important to note that the lower limit and whether it falls underneath the category. And then next slide. If the employee feels that an error occurred, the employee may submit this request for appeal. The BA recognizes an enrollment error was made and fills out section 4 and 5 of the appeal form. It creates a lot of delay and lack of correction for the employee when it gets sent in as an appeal. It has to go through the whole process with the Office of Legal Affairs. It gets sent back generally either to the employer, who then has to submit it through Fuse. So it's really important that the benefit administrators recognize that if this is an error and it falls under error correction, to follow the process as written on the form so that we can start error correction. Also, a second reviewer really needs to review that decision. A second set of eyes helps to alleviate some of the error when it gets sent on to an appeal. I know it's easier to, shuffle it under the rug or just, send it off and let somebody else make that determination, but it's costly to the agency as it delays enrollment for the employee. Therefore, if the employer is having to reconcile the premiums or claims, any of that, it's more costly to you as an employer. It's not going to go away. It has to be corrected. And so it's really important that you send it in through outreach and training. You may want to mark error correction somewhere on your fuse, and so that we can move forward with getting the account corrected and reconciled. All right, and now it's back to you, Zach.
Thank you, Tracy. Section 6, once you're done filling out sections 4 and 5, you move on to section 6, and that is for whoever the secondary review is done by, and for their employer's signature. Once the employer signs this section, they need to return the form to the appellant. The employer should also keep a copy for their own records. At this point, you should be directing your employees to follow the directions in sections 7 through 9 if they wish to continue on with the appeals process. Next slide. The employee needs to complete the remaining sections of the form and submit their appeal to the PEBB appeals unit. Their appeal needs to be received by HCA within 30 days of the date the business administrator made the decision. Appeals are considered to be timely if we have received the appeal. We have to have received the appeal by the 30th day of the employer's response. If it has been received after 30 days, it is considered untimely and will not be processed. A letter is mailed out to inform the appellant if their appeal is determined to be untimely. Next slide. Section 7 is for the employee to explain why they disagree with the employer decision or add anything additional as to what they are asking for in their appeal. Again, employees / appellants should be encouraged to go into as much detail as possible and submit any supporting documentation that they may have with their appeal, including screenshots or any other documents that they may have. Next slide. Sections 8 and 9 include representative and appellant information. Important to note that a representative could be an attorney, but it does not have to be an attorney. If the employee has a representative, they can provide that person's information here. We will need to have documentation on file, such as a power of attorney or a release of information submitted with the appeal for us to be able to give that representative information about the appellant or their account. It is important to note that the representative cannot be an employee of the PEBB organization or HCA. Release information can be found online and is linked to the slide. Appellants need to sign section 9 and follow steps on where to submit the form at the bottom of this page if you wish to appeal to the appeals unit at HCA. We do not have a way to accept appeals via email at this time. We hope to have an option like this available soon, or have an online portal or something like that in some point in the future. And it's very important as a reminder that we do not accept appeals through Fuse. While the error correction process has to go through Fuse, the appeals get slowed down by going through Fuse. So it is important to note that we do, however, have the ability to send appeals decisions to appellants via email. In order for the appeals unit to send an order to an appellant via email, the appellant must select the option in section 9 and provide their email address and sign this section. This option is now added to the appeal form and to program decision letters. This is an important add and could speed up the process for the appellant if they do that. Once an appeal has been received and opened by the PEBB appeals unit, an acknowledgement letter will be sent to the appellant. The letter will state that the appeal has been received, and the PEBB appeals unit will have 10 business days to make a decision unless a continuance is issued. Continuance can be issued up to 30 days for each continuance. Now we'll talk about the authority of the presiding officers, how to read an initial order, and further explanation on the next steps in the appeals process known as the review process. The presiding officer is required by rule to decide issues based upon the information and evidence provided by the parties. The presiding officer is required to apply the WACs and policies as the first rule of law and does not have the authority to decide that a rule is invalid or unenforceable. One question we receive from PEB organizations is, if the BA approved the change requested by the employee in their appeal, why was the appeal denied by HCA presiding officer in the initial order? A presiding officer will look at the brief adjudicative proceeding file, which is comprised of the documents from the program, the employer, and the employee, and then apply the applicable WACs and program policies to those facts and to make a determination. It is less based on the employer decision, or not necessarily. The PEB Appeals Unit response. So when gathering evidence and information to add to the brief adjudicative proceeding file, staff in the PEB Appeals Unit will reach out to PEB organizations to request documentation or evidence regarding the appeal. The PEB organization is required to respond within 2 business days and provide the requested material to the PEB Appeals Unit and the appellant. Next slide. A presiding officer may request additional information from either the appellant, the PEB organization, or the PEB program. If no documents are received, then a presiding officer will be required to make a decision on what information is available, and it may lead to an unfavorable result. A continuance is usually included with a submission of documents order, allowing time for the information to be sent to the PEB Appeals Unit. Again, a reminder that WAC requires the PEB organizations respond to requests within 2 business days. Next slide. Converting to a formal hearing. What happens to, during this? So WAC 182-16-2160 says that the presiding officer or the review officer may convert a brief adjudicative proceeding to a formal administrative hearing. And what does this mean and what will happen? Well, first, the notice of a notice of hearing from the Board of Appeals is sent to the employee and will contain the location, the time of the hearing, and login information. This notice will also contain deadlines for submission of additional information or documents for consideration by the formal hearing officer. Generally, these hearings are held by telephone. They are usually scheduled for an hour, but could extend longer if more time is needed. The PEB program may call witnesses or request declarations from the BA for the PEB organization. It really depends on the issue at hearing. If a BA is called, generally the questions for the hearing will involve your history, training, normal work processes, and how you came to determine the eligibility decision or enrollment decision or whatever the issue is at hand. The employee is allowed to have someone else represent them at the hearing as long as they are not an employee of HCA or its agents, and the HCA won't pay for an attorney. A final order from the hearing officer will be sent out. The employer will get a copy of the final order, and that is pretty much it. Next, we will look at how to read an initial order issued by a presiding officer. The top right of the page contains important case identification numbers. It will have the case number as well as the appellant's name. The issue statement under section 1 will summarize the appellant's request that the presiding officer is reviewing, and is usually a question statement as posed here. The brief adjudicative proceeding file mentioned in section 2 will include the information that the presiding officer is reviewing, and it contains the documents the presiding officer uses in order to make their decision. Next slide. Section 3 of an initial order will contain a statement of facts which are relevant to the case. Every fact in this section will have a citation to the brief adjudicative proceeding file or where that fact came from, as in a judicial notice for the dates of open enrollment, for example. Next slide. Section 4 are the conclusions of law. The laws that are used are located all on the Washington State Legislature site. PEBB eligibility and enrollment, Washington administrative codes are 182-08 and 182-12. The appeal WACs are found in 182-16. All laws that are used will be provided after each statement of law. The presiding officer will provide the rule and then apply the rule to the facts from section 3, and then will issue a decision on the case based on that. Finally, in section 5, there will be an order which either affirms or reverses the decision made by the PEBB program or PEBB organization. Next slide. If the presiding officer affirms the decision of the PEBB organization or program, that means they agree with the original denial. If the decision is overturned in full, then the presiding officer finds that the decision from the PEBB organization or program is incorrect, and the presiding officer is reversing that denial. There is a possibility to have a partial affirmation and partial denial, depending on the issues in the case. Next slide. Once the initial order has been issued, an email with a courtesy copy of the order will be sent to the benefit administrator on file. Note, if the PEBB employer's it's the PEBB employer's responsibility to notify outreach and training of any BA staff changes for notifications. Outreach and training will notify the appeals unit of any changes to the contact list that HCA uses. Next slide. If the employee does not agree with the written initial order, they have 21 calendar days from the date the initial order was issued to request further review by a review officer. This request for review can be written or orally from the appellant. Instructions on to the appeals unit. Instructions on how to do this will be in the initial order. If a request for review is received after the 21st day, it will be considered untimely, and an untimely letter will be sent to the employee. Per the applicable WAC, this must be received in the appeals unit by the 21st day. The appeals unit does not go by the postmark date. It is the date that it was received by the appeals unit. Next slide. Additionally, information on requesting a review of the initial order is included at the end of each order in something like what will be on the right-hand part of the screen right now. To request review, the employee must file a written or oral request for review to the PEBB appeals unit. The request for review may be received by mail, fax, or through the telephone number provided. If the appellant requests review of an initial order within 21 days of the date the initial order was issued, the PEBB review officer will review the decision of the presiding officer to ensure that the correct application of rules to facts was applied. The review officer has similar authority to the presiding officer, wherein they can issue submission of documents, orders requesting further information, or issue continuances. The review officer will send a copy of the final order to all of the parties within 20 calendar days of the request. Once a final order is issued, the employee may request judicial review of the final order. To do so, the employee must file a written petition for judicial review following the requirements in RCW 34.05.510 through 34.05.598. The PEBB program may not request judicial review of final orders. Judicial reviews are heard in Superior Court, and an appeal cannot be filed in Superior Court until a final order has been issued on an appeal and all administrative remedies have been exhausted. It's important, I'm going to repeat that one more time. An appeal cannot be filed in Superior Court until a final order has been issued on an appeal and all administrative remedies have been exhausted. The next couple of slides will help show where employees can access the appeals form. Once you are on the home page, you can click on the Public Employees link. Next slide, then click on File and Appeal. Finally, you will click on the link under the box of what is the appeals process. And then you can click on the most current appeal form. It is very important that the BA doesn't save a copy of this appeal form for future use, as the form is updated from time to time. Next slide. When to appeal to your health plan. So more information on when to when and how to appeal to your medical, dental, or vision plans will be found in the certificate of coverage for each of the plans. If the employee's issue involves claim payments or claim processing or reimbursement for services or supplies, or involves a pre-authorization decision, those requests have to go to the specific plan to appeal. The employee will need to appeal to the specific plan. More information on how to appeal can be found in the plan's certificate of coverage. Similarly, all the certificates of coverage can be found in our website in the forms and publications area, clicking public employee, and then the topic is certificate of coverage. This is just a summary slide of what we've kind of talked about, where do employees or dependents appeal decisions. So if it's a decision made by the PEBB employer, then the PEBB employee request for review or notice of appeal form is used. If it's the PEBB program, they can go directly to the PEBB appeals unit. And if it's a health plan or insurance carrier decision, as in a decision made regarding claims payments or processing, they contact the health plan, and that information can be found in the certificate of coverage. The last few slides we have upcoming are review slides, and I'm just going to talk through them, but it's important that employee has 30 calendar days to file a request for review after the date of the denial notice. PEBB employer has 30 calendar days after the date the request for review is received to conduct a review and provide a written response to the employee with a copy to the PEBB employer, as in filling out sections 4 through 6 on the appeal form. Then the employee has 30 calendar days after the PEBB employer's final decision to appeal to the PEBB appeals unit. Next slide. The PEBB appeals unit has 10 business days from receiving the request for review / notice of appeal form to provide employee with the written initial order that can be extended with a continuance or a submission of documents order with a continuance. An employee has 21 calendar days from the date the initial order was issued to request further review. So once the presiding officer issues an initial order, they have 21 calendar days to request further review. PEBB review officers have 20 calendar days from the request for review to issue a final order, and of course they have the ability to continue that as well. The next slide is a good slide possibly to print out and have with you, and this is just kind of a summary of the appeals process and important date deadlines along the way. Next slide. So again, it's very important that you don't submit appeals through Fuse. You can submit error corrections through Fuse, but appeals that are submitted through Fuse slow down the process. Outreach and training via Fuse and the 800 number is for benefit administrators only. Employees should not be given this information. Fuses are for general appeal-related questions and requests for status checks as needed on an active appeal. If BAs can send questions regarding PEBB benefits outside of a specific appeal through Fuse. Next slide. The PEBB enrollment guide has information about the appeals process. The appeals information can be found on page 63 of the 2021 enrollment guide, and our PEBB appeals unit contact information is there. Employees should not contact us directly. Employees should submit appeals to HTA by fax or mail. Our contact information is right here, the PEBB appeals unit and our fax number, as well as our mailing address. Please send appeal related questions through Fuse, but do not submit appeals through Fuse. And thank you, everybody. That wraps up our presentation on the PEBB appeals process.
Well, thank you, everybody. Do you have any questions for Zach and Tracy? Looks like they have a couple questions, guys, through here.
Well, we are going to answer questions through email or through Fuse. That is the plan for questions, but please add them in the box, and our plan is to reach out through email and Fuse to everybody who has a question if they have one. So
Thank you, Zach. So if you have any questions, please go ahead and type them out and we're going to get back to you with some answers for you. If not, I will thank you for coming and attending the webinar, and you guys have a great day.